Good afternoon. How's everybody?
Good.
Good. I want to thank y'all all for being here. And just as I did, I think it was a few cold Wednesdays ago, maybe January 10th, when I assured a number of people that we were going to be working on a bill that people were going to be happy with and that was going to pass the test of time, was going to pass muster. We've been working on that ever since. And I assured a lot of folks in this room, in fact, that was going to happen on January 10th. And we've been working toward that since. The Senate substitute reflects the gravity and importance of the adoption issue. And I will turn to Senator Calsert to make some comments, and then we'll kind of toss it back and forth. Thank you, Majority Leader Calsert.
Thank you, Mr. President. Well, thanks so much for coming today. We're all happy in the Senate that we've passed this bill. We know it's an important issue. It's been in the public eye for some time now. It had a couple of years of work while it was in the House, and we got it at the very end of last session and spent a good bit of time in committee last session and again in the off season with our study groups, and again through Senator Stone's committee this year. It's passed out with some significant changes. We're excited some of the problems this addresses. We do have an adoption and a foster care crisis in this state, and we're committed to doing whatever we can to help solve that problem. House Bill 159 was a good starting point, but at the end of the day, we felt like we could improve it to do more to protect the people most affected by adoption. And that's the people going through that process. We care very strongly in the Senate about birth moms and the adoptive families and the foster children. Are trying to promote their interest more than the private attorneys that may have other interest in this process. We commend Representative Burt Reeves for the work that he's put into this bill, but we also want to thank Chairman Stone, the Lieutenant Governor, and all the other senators that have helped improve upon this bill from the original version of House Bill 159. The original House bill would have lowered the age for single adults down to age 21. Now, this is single adults, not married people, to adopt children. Under current law, you have to be 25 to adopt if you're single. That does not apply if you're married. You can still adopt children at 21 if you're a married couple. And our bill makes an exception for siblings. If you are at least 21 years old, you could adopt one of your own siblings if you're otherwise suitable for that. So you can see what we're trying to do is anything we can to keep families together. So we felt like making that exception for relative adoptions was understandable. But allowing any unmarried 21-year-old to adopt was just too broad of a stroke. And since we don't take this lightly, we wanted to keep that 25-year-old restriction for unmarried individuals to adopt. So what we're trying to do is balance the interest to encourage adoption, but also protect the interest of the children. And there's several other points where we made changes. Senator Miller, I think you had a couple you wanted to address.
Sure, that'd be great. And then I'll bounce it back to Bill, and we'll go from there. As many of you are well aware, House Bill 159 would have expanded the living expenses for expectant mothers who are outside the adoption agency system. In effect, this would allow the expectant mother's living expenses in the last trimester to be covered and driving up the cost of adoptions. All parties want to ensure that mothers choosing life and adoption have a safe, comfortable place to live with the appropriate prenatal care, and that's why Georgia allows agencies to pay appropriate living expenses. We also do not want to drive up the cost of adoption by making living expenses available to attorney adoptions. Private attorneys do not face the same oversight and scrutiny and regulations imposed on agencies. Adoptive Families and Adoption Resource Group surveys adoptive parents on the cost and the timing of their adoption experience, and the results have shown that expenses are higher for a private attorney versus agency adoptions, and the last thing any of us want to do is drive up the price of adoptions. Under the Senate bill, expectant mothers can work with agencies to obtain living expenses, but limiting living expenses to those paid by agency oversights and cost containments is accomplished preventing escalation of adoption costs. While we have no quarrel with attorneys in general and adoption attorneys in particular. That bill, that House bill as it read, would have benefited private attorneys at the cost of adoptive parents. Let's keep first thing first. And the first thing is the expectant mother, the adoptive parents, and the newborn child. And after all, we all know, I don't know personally, but I can imagine what a gut-wrenching experience this is, both for the expectant mother, but also for the adoptive family. Another point I'd like to clarify is that the Senate tweaks on House Bill 159 allow the birth mother to waive her rights for revocation 72 hours after placing the child with adoptive parents, provided the mother is 21 years of age, and Bill hit on that a moment ago. Also, the elephant in the room is the record that reveals that the amendment offered last year would have preserved the First Amendment rights of faith-based adoption agencies. And in the wake of the controversy of the muckraking, I guess is the appropriate word, the wake of the muckraking and the controversy surrounding that proposal, the authors of that amendment have graciously and magnanimously agreed to put the immediate needs of children first and agreeing to a standalone bill on the religious liberty, which we all support because of prudence and the character demanded as such. We simply couldn't allow progressive hyperbole and the impediment of the obligations that have to our Georgia families and to all kinds of our family values reflected in House Bill 159. We remain committed to not to overdo the statement, but to make sure that we have that standalone vote on our First Amendment rights that we were guaranteed 200 years ago and we look for today. I think Leader Calvert also hit on the topic of folks that have been personally involved and personally engaged and stakeholders in this bill. I'd like to recognize and commend Chairman Stone for his work. It was absolutely excellent. We also had Senator Greg Kirk, Blake Tillery, Senator William Ligon, John Kennedy, David Schaefer, Lieutenant Governor Cagle, Speaker Ralston, and of course, as Leader Calvert points out, Representative Burt Reeves, that we all want to recognize and thank them for the input. But you know, before I turn it back to Bill, I'll say that a wise man once said that true statesmen are concerned about the next generation, and politicians are concerned about the next election. I think this proves that we're concerned about the next generation of Georgians, and these folks, these children, who are our most vulnerable members of our entire society. We have to put them first and their families first. So, Leader Calvert, I'll turn it back to you.
I thought I'd just touch on one other section of the bill that seemed to have gotten a lot of discussion and debate today, and I hope many of you were able to listen to the debate on the Senate floor. I thought there were a lot of voices that articulated some of the differences in the Senate version from the House version and gave you a pretty good flavor of what we're trying to accomplish and how we think this is best for the children of Georgia as well as parents in Georgia. We certainly honor and respect the governor and his concerns. In particular, part of this bill includes House Bill 359, which was vetoed by the governor last year. We definitely respect the Speaker of the House, who's made it clear his preference was for a clean bill to come back. I'm not certain exactly the definition of a clean bill, but I know that he did not want it to get bogged down in the debate over the religious freedom issues that Senator Miller just discussed. Those will be handled separately. This does invite participation, though, from faith-based organizations in helping with the foster care program and adoptions in our state. They have been a partner for many, many years and will continue to be so. And I'm sure that the faith community will be enthusiastic about this bill and looking forward to further improvements down the road. Reverend Andy Stanley had a letter on each of our desks today thanking us for our work on this bill and encouraging us to pass the bill with House Bill 359 included. Just for a refresher, those of you who are not astute on that, that was a parent's ability to have a temporary power of attorney for their child rather than turning their child over to the foster care system if they were temporarily unable to care for their own child. Limited to no longer than a one-year period, and it would envision circumstances such as active duty, being posted overseas, or having a job change where you had to move, having financial difficulties where perhaps your house was foreclosed on, where you couldn't provide adequate housing for a child for a length of time. This opioid crisis that is so prevalent now, a lot of people that are seeking rehabilitation services for addictions. It could be for opioids or alcohol or other problems. There may be limited time periods where they are unable to care for their children. And this portion of our bill looks after them by allowing a parent to, not only, a current law lets you leave a child with the grandparent, but it widens the group of relatives you can leave a child with under a power of attorney. That can include the assistance of faith-based organizations, which Reverend Stanley says he is highly involved in. So your church community could provide a temporary home for your child as you got your life in order. And so you don't necessarily have to give up your child to the state to DFACS and a foster care program if you know there's just a limited period of time that you're unable to parent that child. It seems to be a great aspect to empower parents to do what they think is in the best interest of their children without further adding to the burden on our foster care system under these circumstances. So that's something we're excited about. Obviously, it's a House bill, passed the House last year, passed the Senate last year. The governor expressed some concerns with it. We hope that we've addressed those concerns in this version of the bill, but we're certainly willing to continue working with the governor, with the speaker, with the House, and all the other senators who have vested interest in this bill to make sure that we come up with a final version that satisfies the needs of Georgians, both the children of Georgia and the parents of Georgia. So I will step aside. If anybody has additional comments, I want to thank all of you for coming. We will be giving you a press release here shortly that summarizes these topics as well as a little bit more detail. And again, I would hope that you were able to have watched the debate, because there were a lot of very good points made there as well. Thanks so much for coming today.